agreement by our outside legal counsel, Michael Durkee. So with the council's indulgence, I'll ask Mike to appear before the council at this time.
Certainly.
Thank you, Mike.
Thank you, Mike. Mayor Chavez, council members, it's a pleasure to be here this evening. I did this as well at the Planning Commission, so new form. I hope you'll indulge me for a moment. I wanted to thank publicly all of the parties involved. I think you've got A-plus staff from your city attorney and city manager through the ranks, Guy Petzold, Mike Niblock, Dave Stagnero, Barbara Berlin. Everybody was A-plus. Everybody came to the meetings prepared, did the work when they were supposed to. These took a lot of time and effort, and everybody showed their professionalism in doing that, and I wanted to thank them on the record. The same goes with the developers and their attorney, Mike Hakem. I think everybody really showed up with resolution in mind, trying to strike a bargain that both parties could support, and that's where we are tonight. So I wanted to publicly thank them. Generally speaking, development agreements come in the following fashion. You have a developer interest in knowing the risks that will be involved with future development. As lay people see this on TV, they think, well, I got approved last night and we're done. But to the developer, it's not done at all. It takes years to put these projects together. It takes even longer to implement them, and things change. And so the idea on their side of the equation is to try to know what the deal is so they can decide whether it's a good one to invest in and move forward, all the time knowing that laws change and risks come and go. So theirs is a risk analysis approach. On the city's side, the city wants to make sure that it's done a good job originally with the project, that it continues to do a good job with the project, and that it continues to hold its discretion over that project as in the future entitlements are needed. And the compromise of these is a development agreement where we set the rules, we set the risks, we understand what the role of the city continues to be. For the development agreement that you have in front of you, I'm going to break it down into three major pieces, and they're remarkably straightforward. It wasn't remarkably easy to negotiate it, but I think at the end of the day we came up with a pretty good package, I think, that you should be very pleased with. Development agreements come in three major pieces. They're going to come with the recitals, which are going to be the preamble in the recitals, and they're going to tell you who the players are, and they're going to tell you the project, and they're going to tell you which approvals are being given, including the ones listed tonight. Those would be set forth in the recitals. You're going to know instantly what this project is, who's doing it, where it's located. The recitals are also going to start to define terms. So with any agreement of this length, it's important that we start truncating wherever we can and starting to use words that reappear. Instead of saying a long sentence, we can turn it into a concept, and then we use the concept. So you're going to see those at the very beginning of Article 1. All of the definitions that we use in the development agreement find their home there. City of Stockton becomes city. The Mariposa Lakes folks become developer. All of the major concepts we use are truncated down into an easy-to-use abbreviation, and then we go forward. Dave Stagnero already told you we started with a 20-year term. And the deal that we made with the developers, things started off a little bit shaky. And everybody wanting to know, am I going to get a deal different than the gentleman sitting next to me? And so we really tried to support a system that said, while we were negotiating with Mariposa Lakes, we were also negotiating with Tidewater. We were also negotiating with Groupie Sanctuary. And so if the Groupie folks came up with a good idea that the city could support, everybody benefited from it. All of the agreements were amended to include that. If the city had something important that they wanted on a particular project, then that important city goal was put through all of the development agreements. A very long way of saying that you ended up with three identical development agreements. The recitals are different because they're different projects. But the requirements that you asked them to do, the benefits and burdens of each of these agreements, are identical. And that was the deal that everybody made. That as Arnez advances a very good idea, which they did on the term, that Mariposa and Groupie would benefit from it and so forth. So what we ended up with the term is moving from 20 years, understanding the market that we have now, is that there's a maximum of 25 years. It's 20 years from the issuance of the first building permit. Hopefully we will be issuing building permits in a few years, and so the 20 years would run from that. So this term could be 22 years or 23 years. The maximum term is 25, so that you understand. So it runs 20 from the first building permit. If no building permits are issued in the first 5 years, the maximum term is 25 years. it was important to us as the city to make sure that these projects had a beginning and end. And so there's a lot of bootstrapping that can happen with development agreements, and we wanted the developers to understand that you have a time to make hay, and it's going to be the term of this agreement, and there's not going to be clever ways of stretching the agreement beyond that term unless the city joins in that and assents to an extension of the term. So we tried to make it very clear that the term was finite and the rights given by these agreements would be finite. The other part we wanted to make very clear that as a home buyer or a user stepped into the space, the development agreement would terminate for that person. A lot of confusion sometimes happens if somebody has a recording against their property like a development agreement. They buy their home and they're not sure what that development agreement means to them. So we have the development agreement in place as the developer needs it and is moving forward. As soon as the product's done and the home is built, the development agreement lapses just for that particular unit. So the home buyer does not have to worry about what does this all mean vis-a-vis me and my mortgage. So the first thing we do is the recitals. The second thing we do tends to be boilerplate stuff, and the third thing we do tends to be the power provisions. So we've gone through the recitals. That tells you the project. We know what the term is. The boilerplate's going to be, where do we send notices when we send things out? Well, we list the city attorney and your address here. We list the developer. What kind of insurance are we going to make you carry on the job? They're very standardized provisions. You read those. That was sort of Articles 3, 4, and 5. The power provisions are all in Article 2, and I want to spend just a minute explaining how that works to you. So in this concept, what we do is we build a yardstick. You're going to have a yardstick that you're going to use for these projects, and it's called the applicable law. And so the applicable law is basically, if there's a question 10 years from now, we're going to know that this project has applicable law. The applicable law is going to be the deal made through the agreement itself. So any particular provision in the development agreement is going to be part of the yardstick that we use for the project. It was very clear to staff that the council supported the climate action plan, that the council supported the settlement with the Attorney General and the Sierra Club. So that's clearly part of the applicable law. That will involve future laws that the city will do through the climate action plans, through the early climate protection actions. All of those things are going to be a part and parcel of your implementation of that settlement agreement. This agreement makes it very clear that those future laws are subject to this project. These projects, strike that, reverse it, these projects will be subject to those new laws. Existing approvals. Many of these projects are going to come to you with certain existing approvals. That becomes part of their body of law. They'll be asking for subsequent approvals beyond this, tentative maps, other things as these projects implement. That becomes part of the applicable law. And then lastly, new city laws. And we had to make it very clear that there'd be three kinds of new city laws. There'd be new city laws that do not conflict with any of the things I've just described to you, and they should be subject to those. There'll be new city laws that implement the action plans, the climate action plans, the settlement agreement, and they'll be subject to those. And then there'll be new city laws that they want to be subject to. There's a break in fees. There's a more favorable status in a future city law. They can raise their hand and say, normally I'm not subject to that. I'd like to be, please. And then that becomes part of their applicable law, too. Section 2.02, having defined the applicable laws, says we both get a right to it. So the city uses that as its yardstick, and the developer has that as its profile of risk. These are the things that could change on me, and I understand what they are. It's important that you understand, again, that you are maintaining your discretion over future actions. It's just subject to a known yardstick, a known ruler of laws. 2.03 is the Attorney General provision. I'm not going to belabor that, but it makes it very clear that everything that you agreed to in that settlement agreement now becomes law of this project. Section 2.04 is probably a section worth spending a moment on, and that is to simply say, I'm a big believer, and I watched your staff do it, so I'm very proud of them being big believers, that all of the things that you would put into a development agreement, you back into the policy documents themselves. So if the Attorney General settlement is a good idea, then that should be part and parcel of the specific plans and the zoning and the other things that you do. If you decide that you want fiscal neutrality and that projects should carry their own weight, then that shouldn't just be in a development agreement. That should be in all of the documents that lead up to a development agreement. And that's what your staff has done for you. So many of these ideas are echoed in the development agreement, but they actually find their homes in the base planning documents that you're going to consider this evening. 2.04 is no exception. That simply says right on its head, you shall be fiscally, physically, environmentally neutral to the city. That if you put a burden on the city, you shall carry that weight. 2.05 makes it very clear to the project that as construction codes change, they'll be subject to them. So Mike spoke specifically about Build It Green and LEED Silver, but you're going to see over a very short amount of time, probably over the next 5 years, building codes get remarkably green, and they will be subject to those too. The changing codes will be something they're subject to. The next section, which is 2.06, tried to do two balancing provisions, which is it's important for developers to be able to control their timing, their phasing, their sequencing, because they know their market better than any legislature ever could. I'm a big believer that the market finds its own level in that way. But because we are doing a climate action plan, it's clear that that is going to dictate some level of sequencing, what happens when. And so this did a compromise, and it says, to the extent the climate action plan speaks, it controls phasing. To the extent that it doesn't, the developer is going to control phasing, because they are going to know best where they need to go and when. 2.09 is new city laws, and we talked about it. Things like the Climate Action Plan will be subject to them. They may elect to be subject to new laws if they choose to. And then the last one I want to touch on is Article 3, and that's kind of the overview, and that just echoes again what I said earlier, that when you process them, you process them. You know, D-U-E, due process, means D-O, process. And so that's all this section's doing. It's saying they have a right to come in and put in their applications. You will be processing them. The yardstick that you'll be processing them under is the applicable law that I've described. But if you find under that applicable law that this application they're submitting to you doesn't fit, you absolutely have the right to say no. So I'm happy to take questions now, later, whatever, Mr. Mayor, you prefer.
I don't see any questions right now. Thank you.
Great. Thank you.